rise. Further hearing in Lee against Ashford Baker Company Limited and others, and the Northern Ireland references.
Yes, Mr. Attorney.
Ladies, Lords, you have before you today two references, three questions in one and one question in the second. And while formally the references have nothing at all to do with the permission to appeal in the case of Lee against MacArthur, of course the facts, the fascinating facts of that case naturally inform and give colour to our references. And it's helpful, I suggest, to have regard to the way in which the matter is put in Mr. Lee's skeleton argument before the Court of Appeal at paragraph 13 and footnote 10. It's MS 3591. We're taking issue with the characterisation that the appellates give to the case as being about a slogan. He says, no, it's about a message, because slogan would tend to detract from the content. And we, for our part, respectfully agree. It is a case about a message, and it's a message with content. Now, the questions, of course, are before the Court. I won't take up time, which is scarce, by going through them. They're tab 6 and 7 of the core volume. These submissions are in 7 parts. And the course that I propose to take is firstly to look at the constitutional background and at the constitutional limitations on legislative and ministerial competence in this jurisdiction. Secondly, to look at the meaning of discrimination under those constitutional provisions. Thirdly, at the application of the indissociability test to the expression of religious and political messages, including compelled expression. Fourthly, I look at the liability creating provisions of veto and SOR and the provisions under which they were made, because that's relevant to the particular constitutional limitations. Fifthly, I look at the role of the Convention as regards SOR. And sixthly, I look at the issues around the limitations on the power to refer under paragraph 33 of Schedule 10 to the Northern Ireland Act 1998. And seventhly and finally, I propose answers to the questions referred. So, can we begin then with the constitutional context? And can I, with apologies, draw attention to a further small sheaf of documents which I've asked to be handed out this morning. It's a small 4-tabbed little sheaf of documents, and I'll be referring in this first section to the first 2 tabs. That's the extracts from the Government of Ireland Act 1920 and the extracts from Queckett. But it's worthwhile emphasising that from its creation, Northern Ireland has always, but in different ways, prohibited legislation that discriminated on the ground of religious belief. And the starting point is Section 5 of the Government of Ireland Act 1920, which in unamended form the Court finds at Authorities Volume 1, MS 183. What's significant about Section 5, of course, is that Section 5, when originally enacted, wasn't simply designed to protect a Catholic minority in Northern Ireland. It was also designed to protect a Protestant minority in Southern Ireland. and the court will know that the scheme contemplated by the Northern Ireland Act 1920 was of two jurisdictions, both subject to the 1920 Act, but with the possibility of them merging through a device that was already contained in the Act of Council of Ireland. Now, I'll interject at this point to discuss one issue which arose in the context of the question of appeal rights. That's not an issue on which I propose to make any submissions, subject to being asked by the court to do so. But what I thought I should say was to correct an impression given by my learned friend yesterday about the very limited nature of appeal rights from the Northern Ireland Court of Appeal. He suggested that there was a limited appeal right to the Privy Council in relation to the validity of legislation. In fact, the position is substantially different. If one looks at the first tab within the new bundle and section 49, an appeal shall lie from the High Court of Appeal for Ireland to the House of Lords. And then this is section 49, my Lord. I won't see that. I won't dilate on those, but ask the court to simply note this: that this is the Court of Appeal for Ireland. This is the Court of Appeal established by other provisions in the 1920 Act, from which an appeal lay from both the Court of Appeal in Northern Ireland and the Court of Appeal in Southern Ireland. And true it is that in the 1920 Act there is provision for references to the Privy Council, but that's additional, and one finds that in section 51. Now, of course, as we know, the Government of Ireland Act was largely a dead letter in Southern Ireland, to use the term contained in that Act. And therefore, to see what happened in practice, one looks to tab 2. And in tab 2, one has in Queckett, volume 2, an annotation on section 49. And one sees that immediately in the first sentence, an appeal shall lie from the Court of Appeal in Northern Ireland, footnote 1, Court of Appeal in Northern Ireland, and then there's a reference to the 1922 Act. This court was substituted for the High Court of Appeal for Ireland. And I won't spend much time on this, but I'd simply ask the court to look at internal page 81 and note B. And the effect of the Government of Ireland Act and the subsequent enactments is to widen the appellate jurisdiction of the House of Lords. And then the learned author dilates a bit on that. So, in summary, there were generous appeal rights to the House of Lords. At least that's the way Queckett viewed it, from the Northern Ireland Court of Appeal as originally established by the 1920 Act. And in fact, there was an appeal, briefly, to a further Court of Appeal on this island, the High Court of Appeal for Ireland. So, I've given the court the reference MS 166 to the Government of Ireland Act, MS 183, and I won't read section 5.1, but it's again an example of very much the style of drafting at that time. It goes into considerable particularity in relation to the issues that it addresses. Fast forward then to 1973 and the Northern Ireland Constitution Act of that year. That's Authorities Volume 1, tab 18, MS 166. And That uses rather more modern language, and it imposes a limitation on measures of the Assembly, acts of the Northern Ireland Parliament. And the important point about Section 17 is that although it was primarily intended as a limitation on the legislative competence of the short-lived Assembly of that time, it lived on and has impact on the orders in council made under the Northern Ireland Act 1974. And there is, I won't take the court to it, but there's an example of a challenge, a much earlier challenge than this one, a challenge based on the 1973 Act to an order in council in Daly and others, which is at tab 11 of the additional appeal documents.
Yours or the big edition?
The official additional appeal documents.
Well, we wouldn't like to suggest that yours are not official.
Well, indeed, the ones with misleading MS numbers, if I can put it that way.
Yes.
So it's tab 11 of that. I'm afraid I would be only giving misleading MS numbers, so it's tab 11.
In this document, we don't have tabs, at least I don't.
No, we don't.
If you can give me the misleading MS number,
Right.
I can find it in hard copy.
I'm very grateful.
Oh. Simply visible. Yes, indeed. Thank you.
And the first page suffices because Lord Justice McDermott states the question, so we can see the issue that is before the court. And Section 23 of the 1973 Act, which is at MS 167, defines discrimination. For the purpose of this Act, a measure, an Act of the Parliament of Northern Ireland, or any other instrument discriminates against any person or class of persons if it treats that person or that class less favourably in any circumstances than other persons are treated in those circumstances by the law for the time being in force in Northern Ireland. And helpful perhaps for the court to note at this stage that the words of Section 23(1) of the 1973 Act, MS 167, are identical from the word discriminates onwards to those found in Section 98(4) of the Northern Ireland Act 1998, also from the word discriminates, and one sees that that's at MS 130. Of course, I referred to the Assembly as short-lived, and by 1974, provision had been made for dissolution of that Assembly, and direct rule was implemented. And although the 1974 Act envisaged that it was making temporary provision for the Government of Northern Ireland, it continued to govern the exercise of legislative power for this jurisdiction in terms of a series of annual renewal orders until the 2nd of December 1999. And one sees an example simply of the first extension order for the court's note at MS 162. And we know that the limitations imposed by Section 17(1) were carried on into the temporary, as it was thought, law-making powers for Northern Ireland in Section in the 1974 Act, because paragraph 11B of Schedule 1 to that Act tells us so. That's MS 165. So the Privy Council can make laws for Northern Ireland, and in particular for any provision for which the Northern Ireland Constitution Act authorises or requires provision to be made by measure.
Mr. Tenney, is this in your written case? Because I'm not complaining if it isn't, but if it isn't, it's difficult, at least I'm finding it difficult to note down the chain.
The chain is set out.
It might be helpful if you wouldn't mind also referring us to the paragraphs where you actually set it out, rather than try and keep up with you.
Indeed. Well, if one
it's
looks
paragraph 1920.
Yes,
isn't it?
yes. So, to take the matter as far as the 1974 Act and orders in council made under it, any order in council made under the 1974 Act which discriminates on the ground of religious belief or political opinion is void to the extent that it does so. And the limitation is both recognised and expressly preserved in paragraph 21 of Schedule 14 to the current constitutional statute, the Northern Ireland Act 1998, and one sees that in Authorities Volume 1, MS 135. That's the repeals affected by this Act shall not affect the operation of Section 17 and 19 of the Northern Ireland Constitution Act 1973, read with Section 23 of that Act in relation to orders in council made under the Northern Ireland Act 1974. From the 2nd of December 1999, the legislative competence of the new Assembly, as well as ministerial and departmental competence, was subject to the limits set out in Section 6 and 24 of the Northern Ireland Act. And Section 6 is at MS 123, Section 24 is at MS 127. And these limits included the inability of ministers or departments to make any legislation or to do any act which discriminated on the ground of religious belief or political opinion. And in terms of context, it may be noted that the devolution twin of the Northern Ireland Act 1998, the Scotland Act 1998, MS 147, contains no such specific and standalone protection against religious or political discrimination in legislation or, for that matter, in ministerial action. This is unsurprising and reflects a continuation and extension of a classic constitutional response in this jurisdiction to historic and sadly enduring community division in this jurisdiction. And just so that there is no ambiguity about it, we've included in tab 4 of the documents which we provided this morning the commencement provision, not the commencement provision, the introductory provision of SOAR, and one sees that SOAR was made, just tab 4, by the Office of the First Minister and Deputy First Minister. Now, Section 24(1)(c) of the Northern Ireland Act 1998, MS 127, in effect from the 2nd of December 1999, provides that a minister or Northern Ireland department has no power to make, confirm or approve any subordinate legislation or to do any act so far as the legislation or act discriminates against a person or class of persons on the ground of religious belief or political opinion. Subordinate legislation or ministerial or departmental action is therefore formally and substantively ultra vires if it discriminates on religious or political grounds. The definition of discrimination is contained in section 98.4 and 98.6 of the Northern Ireland Act. It's MS 130. For the purpose of this Act, a provision of an Act of the Assembly discriminates against any person or class of persons if it treats that person or that class less favourably in any circumstances than other persons are treated in those circumstances by the law for the time being in force in Northern Ireland. Section 6 does similar effect with respect to 6, no provision of an Act of the Assembly or of subordinate legislation, and no making, confirmation or approval of a provision of subordinate legislation shall be treated for the purpose of this Act as discriminating if the provision has the effect of safeguarding national security or protecting public safety or public order. And while, as we've seen, protection against discrimination, certainly on the ground of religious belief, and since 1973 against discrimination on the ground of political opinion, has been part of our constitutional landscape since 1973, the ability to rely domestically on convention rights was a new element, and it was introduced following the Belfast Agreement, and one sees the relevant provisions of that. Paragraph 2 of Rights, Safeguards and Equality of Opportunity. That's Authorities Volume 8, MS 2666. And of course, in Northern Ireland that was given domestic effect by Section 6(2)(c) as respects the competence of the Assembly, and Section 24(1)(a) as respects ministerial and departmental competence. MS 127 for ministerial competence, departmental competence, MS 123 for legislative competence. And I hope it's a helpful coda to this first section on the Northern Ireland constitutional background if I draw attention to the decision of the Northern Ireland Court of Appeal in Ulster Transport Authority against James Brown and Sons. It's MS 1567. This case is useful on the interpretation of statutory provisions that fall foul of constitutional protections, in that case taking property in Section 5. And Lord McDermott describes the proper approach as horizontal severance, that without excising any of the text removes from its ambit some particular subject matter, activity or application. MS 1567. And
when does what electronic page number does the case begin? Certainly not 1567.
no, that's the passage in Lord McDermott's judgment that I want to draw attention to.
I think it starts at 1558.
Yeah, thank you very much. Just point me again, Mr. Attorney, to the passage that you want to.
It's 1567.
Yes, well, I've got that.
Yes.
Whereabouts? It's very dense text.
It is. It's terribly dense text.
But if you give us a word or two,
Yes.
give us a word or two, and that will.
The severance that without excising any of the text removes from its ambit some particular subject matter, activity or application.
It's about
A severance
six lines
that
down.
is which, without
Yes.
without excising any of the text, removes from its ambit some particular subject matter, activity or application. Which in a way is reading things into the text, isn't it? It's going to say, except for.
But it's leaving it, so it doesn't apply to, it doesn't cover this.
Yeah.
And we say that that's particularly apt in the context of the subject matter here.
Is the UK authority for that proposition?
No, not that I'm aware of.
I wasn't either. So.
No. It's been rather overtaken by events in terms of the interpretive obligation, respectively, in the Human Rights Act, but also specifically in the context of Northern Ireland ministerial, departmental and legislative competence. It's addressed by Section 83(1)(b), which says that if there are a number of readings of a statute, one within competence, one without competence, then one goes for the reading that is within competence. And one finds that at Authorities Volume 1, Tab 11, MS 128.
I'm not sure that I find the concepts of vertical and horizontal severability very easy to grasp, or indeed necessary. The section actually says that it's void so far as it contravenes these restrictions. Well, why isn't that simply consistent with an interpretation that so far as it contravenes them in respect of some particular subject matter, it's void? You don't have to do anything with the wording horizontally or vertically.
Well,
you apply the wording.
Well, perhaps it's a more emollient approach by the Northern Ireland Court of Appeal of those days. What they said, well, that isn't included, and therefore the Act.
But that so far means that anyway, doesn't it? Without trying to work out what is meant by vertical and horizontal severance.
Well, the subject matter, which would otherwise, were it included within the provision under challenge, simply falls out. The statute, one doesn't rewrite the statute. what
Well,
occurs to me...
it's a very interesting approach.
It is. And what occurs to me is that in the context, of course, we pat ourselves on the back here, of course, in having the longest experience of devolution. And of course, it would be highly unusual when this decision was being argued and decided for UK judges really to be pronouncing on the validity of acts of legislative bodies.
Yes, but I echo my Lord Mouse's concern about this. I mean, what contemporary relevance does this have? I mean, as he says, if it's void, then pronounce it void or disapply it.
Well, it's that. Well,
but does one need to get into the business of severing horizontally or vertically?
Well, what one does, it is a more emollient approach that one simply decides that this subject matter, for example, in the context of these references, that compelled expression isn't embraced by either Fito or SOR, rather than having to say that they are pro tanto void.
Well, it is interesting to us to compare Section 6.1
Yes.
of the 1998 Act, which says a provision of an Act is not law if it is outside.
Yes.
With Section 5, which says void so far as contravenes.
Yes.
Well, it's easy to read that as allowing you to say, well, it can apply in its terms to that because that's okay, but it can't apply to this subject matter, this activity or application because that's not okay. It's harder to read the words of Section 6.1 in that expansive sense. And of course, the interpretive obligations under the Human Rights Act seem narrower still.
Well, can I put it this way? The way in which one would apply the approach of Lord McDermott in Ulster Transport Authority to the modern provisions, Section 6, Section 24, would be this, that yes, if you are regarded as having done that, you can't. But Lord McDermott, I suspect his approach would be to say, well, but you didn't do that, and it can't be taken that you have done that. So in the context of this reference, Fito and SOR do not embrace compelled speech. So having looked at the background, can I then turn to the nature of discrimination in the 1973 Act and the 1998 Act? And it's clear that the constitutional protection afforded to religious belief and political opinion extends only to protection against direct discrimination on those grounds. And the issue of what is direct discrimination beyond ex facie discrimination, no hospital places for insert category X, is best answered by reference to and respectfully reliance on the approach of the majority of the Supreme Court in Bullen Hall against Preddy. And in paragraph 19, my Lady Hale refers to and adopts the approach in Schnorbus and Landhessen. And one sees that, MS 607, Schnorbus and Landhessen. I won't take the court to that, but for the note, the relevant passage from the Advocate General's opinion is MS 2217. And the discrimination is direct, where the difference in treatment is based on a criterion which is either explicitly that of sex or necessarily linked to a characteristic indissociable from sex. It is indirect where some other criterion is applied, but a substantially higher proportion of one sex than of the other is in fact affected. And in Bullen Hall against Preddy, my Lady Hale sees the criterion of marriage, this MS 616, or civil partnership as indissociable from the sexual orientation of those who qualify to enter it. Lord Toulson agrees with this in paragraph 67. That's MS 624. He uses the formulation, one cannot separate the sexual orientation of Mr. Preddy and Mr. Hall from the resulting branding of their relationship. And Lord Hughes, who considers that Mr. Preddy and Mr. Hall were victims of indirect discrimination, does not disagree with the use of indissociability as a test. Where he differs, paragraphs 90 to 91, is only with its application, and he sees the subset approach as apt, MS 628, 629. So that takes us to the third part of these submissions, that's indissociability and political opinion or religious belief. Now, the expression of a political opinion is indissociable from the opinion that is expressed. Expressive activity, whether the expression be made in a pamphlet, on clothing, or on a cake, properly and readily attracts the application of the indissociability test. A political belief of whatever kind and its manifestation by expression, whether the expression be on a t-shirt or a cake, these are indissociable from one another. Differential treatment on the basis of that manifestation can amount to direct discrimination on the ground of political opinion. But of course...
Why are they indissociable? I mean, supposing you had an exhibition of political slogans, the exhibitors wouldn't be associating themselves with the political slogans. They'd just be saying, look at all these interesting slogans, some for, some against this view. So they're not absolutely indissociable.
There are those cases around the edge, but I suspect there the item, the artefact, the poster, is being displayed not as an expression of vote for me. It's being displayed, for example, in an art gallery as an example of Art Deco political art of the early 20th century, say.
Yes,
so,
I mean, it no doubt evidences the existence on someone's part of a belief in that slogan, or it's very likely to, but it doesn't mean to say it's the person who's manifesting or expressing it at the particular time who has that belief.
And even in the context of the gallery owner, one can see how if there is, some of this will be simply responded to with relative indifference, but if there is a particularly toxic political view, or one that is regarded as politically toxic by a gallery owner or a gallery employee, and one thinks of slogans advocating race hatred or something of that nature, that the gallery owner says, I'm not putting that on the wall. You know, so even in a context of where it's being placed for display purposes, it's not being placed in terms of formal advocacy of that opinion. One can see often that expression is so loaded that even the laboratory handling of it, to use that formulation, may still cause problems in terms of compelled speech. But in any event,
not in every case. I mean,
No,
take Neil McGregor's book on Germany. There are some striking pages which contain, just to explain what was happening in the Nazi era, some very nasty slogans.
well, indeed,
He certainly didn't endorse them.
But it's an excellent example, because I understand, and my lord will correct me, that in the German translation, some of the images will not have been reproduced.
That's interesting.
And one knows, for example, that even when recently the Bavarian Academy of Sciences produced a scholarly edition of Mein Kampf, the political charge that generated and the controversy that generated in terms of people who, booksellers refusing to stock it and so forth, and matters of that nature. So one can see that even when the matter is viewed, when the text or the image is viewed scientifically, to use that shorthand, it may still possess a powerful charge in terms of people who are opposed to it and will not wish to be compelled to express it. But I was then going on to say, my ladies, my lords, that, of course, while indissociability exists as between the particular opinion and the message, it will often be associated with, but at the same time readily dissociable from other protected characteristics. If a political scientist, for example, tells us that political platform X is more popular among men than women, to visit a detriment on the holders of political opinion X, or those who express political opinion X, may be indirectly discriminatory against men, but it will be directly discriminatory against those who express X. And it's clear in our respectful submission that indissociability is perhaps even tighter when what is at issue is compelled expression. To visit a detriment on those who will not express political message X will not cause harm to those who adhere to the political idea expressed by message X. Those who embrace that idea will be content to express it. Those who are opposed to that political idea will regard it as objectionable, to use no higher word, to be compelled to express it. Or, to use the term common in discrimination law, they will experience a detriment, while those unopposed to political message X will not. And compelled speech to which one objects on the grounds of religious belief or political opinion is to adopt the dictum, modify the dictum of Lord Hope in Shamoon. And Shamoon is Authorities Volume 4, tab 59, MS 127, paragraph 35, something which a reasonable person would or might take the view in all the circumstances was to his or her detriment. Being remembered that detriment was an aspect of less favourable treatment, so you say MS 1207, paragraph 33, and Lord Hutton in Shamoon agrees, MS paragraph 91, MS 1228, Lord Scott agrees and helpfully adds an emphasis on the necessity of viewing the matter from the perspective of the victim. Paragraph 105, MS 1230 going into 1231. And Lord Roger agrees with the finding of detriment in paragraph 148, MS 1243. And of course, Shamoon is a striking case, one of which there is a detriment, but no discrimination. And nonetheless, the analysis of detriment in Shamoon we respectfully commend to the court. And compelling the publication of a political message or the publication of a statement with theological content on pain of incurring civil liability treats those who are opposed to the political message or the theological statement differently and less favourably than those who are not so opposed. In Lee and MacArthur, core volume MS 3194, the Lord Chief Justice contrasts the refusal of a service to those who support same-sex marriage with the refusal of a service to those who oppose same-sex marriage, and concludes that there is no less favourable treatment under the legislation. Both service providers are, he says, treated the same as a result of their refusal, paragraph 99, MS 3221. And we say this is to miss both context and point. The context of this reference is that of compelled expression. That's also the context, I understand, of the appeal. The point is that X is treated less favourably than Z when both are required to express a political message to which X objects on the ground of political opinion and Z does not. The apt comparator for this reference is that between a service provider who has no religious or political difficulty with expressing a particular message, which may be associated with but not importantly is not indissociable from sexual orientation through the service provided, and a service provider who does have such a difficulty because she or he is opposed on the ground of religious belief or political opinion to the message to be expressed. The service provider who is opposed to expressing the message on the grounds of religious belief or political opinion suffers a detriment in being compelled to utter that to which he objects on religious or political grounds. One has violence done to one's conscience, the other does not. And the Lord Chief Justice's view that it is unlawful to provide a service that only reflects a provider's own political or religious belief in relation to sexual orientation, paragraph 100, the judgment MS 3222, is not an answer to the questions referred in this court, which are confined to compelled expression. But if the court considers that it can't avoid consideration of whether an alleged discriminator's own views are capable of amounting to the ground of discrimination, then we respectfully suggest that they cannot be. For this reason, using the template of political opinion to test the proposition. The language that one finds in the Northern Ireland Act, in the Northern Ireland Constitution Act, in relation to the definition of discrimination is the same. Imagine a political party standing on a proposition that it will impose a tax on sugary drinks. It is successful in the assembly elections and is in a position to, by reason of its numbers, get legislation passed which gives effect to its political platform about sugary drinks. Can a manufacturer of sugary drinks say, we're being discriminated on the ground of your political opinion because it's going to cost us more, we're going to lose sales, that's the effect of what you're trying to do, and this is all happening because of your political platform? Well, I may perhaps be accused of burlesquing the issue, but in our respectful submission, the answer is inescapable. And reference was made yesterday to some of the decisions in the Northern Ireland courts, and it seems to me, without taking the court to those, that there is a distinction between where the opinion, the political opinion, or the religious belief of the alleged discriminator causes him to take a view about the religious belief or political opinion of the alleged victim of discrimination. That's different. If, for example, I'm a member of Sect A, and being a member of Sect A, I feel myself obliged to hate members of Sect B. It will be the hatred of Sect B and the quality of possessing Sect B that will matter, not...
Or the less favourable treatment
Yes,
of Sect
indeed,
B.
Indeed. Respectfully agree.
What if, as a member of Sect A, you prefer to appoint someone to a position over which you have control, if he is a member of Sect A?
Then it will be the negative characteristic of the unsuccessful candidates in not possessing that characteristic.
Yes, so the political opinion inspires the choice of someone that you feel that you're aligned with, but the subtext to that is that you're discriminating against the person who doesn't bring that attribute.
Yes, respectfully agree.
I think what we were on about in the case that Mr. Allen was confident would make me blush.
Yes, but it's
But
not
apart from that, of course, reading that case and bringing it slowly to memory, it was a preliminary point case.
It was.
Yeah.
It was. So, in a sense, I too can spare my Lord Kerr's blushes because there's nothing in what he said previously that actually properly analysed stands in opposition to what we're saying this morning. And worth bearing in mind, of course, that Northern Ireland has constitutionalised protection against discrimination on the ground of religious belief and political opinion. There is no analogised constitutional protection for discrimination on the ground of sexual orientation. And far from our constitutional provisions becoming instruments for the support of differential treatment of fellow citizens, which is what my Lord the Lord Chief Justice fears in paragraph 101, MS 3222, they never become so on our analysis. The protections in the 1973 Act and the 1998 Act are against direct discrimination on the ground of religious belief or political opinion. Compulsory expression of words indissociable from religious belief or political opinion is treatment less favourable to those whose political opinion or religious belief renders the words disagreeable, to use no stronger word, than it is to those who support those words. And that applies irrespective of the content of the political opinion, subject to the support for violence exception in FETO imported into the Northern Ireland Act 1998. So, insofar as the legal protection against discrimination on the ground of sexual orientation clashes with the Northern Ireland constitutional protections, as it does, if it does, insofar as it compels expression contrary to religious belief or political opinion, it yields to those constitutional protections. And similarly, insofar as the extension of political protection against, of legal protection against discrimination on the ground of political opinion in service provision clashes with these constitutional provisions, as it does, if, or to the extent that it requires expression contrary to the religious belief or political opinion of the provider, then it yields to them. On the issue of discrimination and less favourable treatment, the matter can, we suggest, be usefully summarised into questions. Do the provisions at issue in the first reference impose civil liability for the refusal to express religious or political message X? Is a person who objects to political message X on political or religious grounds and who is compelled to express it on pain of civil liability less favourably treated than one who does not so object to X? And we suggest that an affirmative answer is inescapably given to both questions. Now, turning to spend a little time on the notion of compelled speech and the risk of a service provider being required by SOAR to express a view to which he was opposed was acknowledged by Mr. Justice Weatherup, as he then was in the Christian Institute case, and he explored the case of Brocky. The note here is MS 1069 through to 1070. That was discussed yesterday. I won't spend much time on that, but simply to emphasise that in that case, for what it was worth, the learned judge suggested that Brocky might be a useful template for future concrete cases. However, as we know, Lord Justice Weatherup, as he became, was part of the court that decided Lee and MacArthur. And it was held that the bakers in Lee and MacArthur would not have been associated with the message. Well, that's not the issue. It doesn't matter if the next customer after Mr. Lee or a wide section of the public did not impute the slogan to the MacArthurs. What matters is that the MacArthurs reasonably saw it as conflicting with their religious beliefs, and it was a detriment for them to have to express that message. It mattered not that a third party would not have associated the printer or the baker with the slogan. The issue is, again, we remind the court of the approach in Shamoon, MS 1207, whether a reasonable person would or might take the view that for her to be compelled on pain of civil liability to express a view to which she was opposed on political grounds was a detriment. And similarly, we said that the Court of Appeal were, with respect, quite wrong to see the MacArthur's, the reference here is MS 2313, paragraph 70, in some way as the authors of their own misfortune, with the forced speech arising only from their wide offer. In terms of expression, that offer cannot have been wider than a printer's, C.F. Brocky, and they were certainly compelled to express that to which they were imposed or incur civil liability if they did not. And again, we will return to this point, but when one looks at the colourful brochure which was provided to the court yesterday, and no doubt my learned friend had a great deal of fun cross-examining about Happy Halloween and Larne Ladies Football Club, but these are globally different. No one cares about a Halloween cake or Larne Ladies Football Club, even if one supports the team up the road. There is a global difference between that and a highly charged political message.
Does authors of their own misfortune appear as part of the
No,
reason?
it doesn't. It doesn't.
Reason,
But
of course, no.
But no. But that's my, perhaps, I hope, not unkind gloss on what they say. Where it's, look, it's the wide offer which brings this down.
Well, that may have contractual consequences if it was an offer. Well, it was certainly accepted,
Yes.
Well,
can I?
Authors of their own misfortune would mean that there was no qualification to what you had to do if you undertook to do a service of printing, for example.
Well, one sees in paragraph 70 that it's the wide offer which brings this down on their head. And we make 2 points. One, that there's nothing. It would simply be unimaginable that someone would come along one day and do this. That one should, of course, never say never. And in response to my Lord Mance's observation about the contractual position, may I say that it seems to me that there was indeed a contract in this case. Yes. It may well be that it's an example of no good deed going unpunished. Mrs. MacArthur doesn't wish to cause a scene in the shop, but she accepts the deposit. And of course, nothing that...
Well, no one suggested that the existence of a contract is the critical element.
No, it's not, but it's interesting that when it comes to the balance later on, because Mr. Lee would, on my submission, be fully entitled to maintain an action for breach of contract if he wished. I mean, obviously this court has looked very recently at contractual damages.
Well, he got his money back, and had he suffered any consequential loss, no doubt that would have been...
Yes, it would. It would. And that wouldn't, on our case, be a problem in terms of compelled speech, because the issue would simply have been, well, next time, say no and don't form the contract.
The issue in this case would arise if the objection had been taken at the point when the original request was made, and so there was no contract. We'd have exactly the same issue.
Though one suspects, of course, on the counterfactual, it may well not have happened. I'm sorry, we don't do that. Yeah. Oh, very well, I'll go to the bakery down the road. And one sees, I won't take the court to it, but there is a sense of disappointment and irritation in Mr. Lee's emails where, well, you told me you would, and now you won't. And nothing that we say on the issue of principle ought to detract from that. Of course, we know that there are important decisions of the United States Supreme Court on the concept of compelled speech. Again, if I may add to what Mr. Allen said about the First Amendment of the Constitution of the United States, it's not an absolute, as he characterised it. It's not remotely absolute. The United States has a law of defamation, and we know that prominent figures regularly threaten to sue, and indeed do sue, one another for defamation. So the existence of a law of defamation is utterly inconsistent with the notion that the First Amendment is absolute in character. Plainly, Justice Hugo Black would have liked to have given it a near absolute quality. We know that, but that's not the constitutional law of the United States. Woolley and Maynard is the, we give the reference there to the relevant passage. It's Authorities Volume 7, tab 1110, MS 2491. This is the great live free or die case, and we'll see again, as so often, Jehovah's Witnesses bringing forward very important constitutional claims to the US Supreme Court. This is one of them. And the court says that the right of freedom of thought, protected by the First Amendment against state action, includes both the right to speak freely and the right to refrain from speaking at all. And the driver was entitled to avoid being the courier for a message with which he disagreed. And that's MS 2492. Hurley against Irish American Gay, Lesbian and Bisexual Group of Boston. There the organisers wished to exclude a group imparting a message which they did not agree from joining the Boston St. Patrick's Day Parade. The US Supreme Court found they were entitled to do so despite the Massachusetts anti-discrimination law. The state, MS 2461, may not compel affirmance of a belief with which the speaker disagrees. And while the judgment of the US Supreme Court is awaited in the case of Masterpiece Cake Shop Limited against the Colorado Civil Rights Commission, we have a really useful, in our respectful submission, amicus brief which is in support of the Colorado Civil Rights Commission from a group of important scholars of the First Amendment, and that's at Authorities Volume 8, tab 116. And if one looks at MS 2581, and the second paragraph, an artisan may refuse to create a message if he would refuse to create such a message for any customer. Thus, a Colorado artisan may decline to create for any and all customers messages saying, "God bless this gay marriage," or "the South will rise again," for the simple reason that the Colorado law does not seek to regulate messages, but to prohibit discrimination against customers. But if a cake
if you're going to cite this as persuasive, it would be a good idea to show us who the authors of this amicus brief are.
Oh yes, I will, and they are but I start really with the name of Floyd Abrams, a very distinguished, possibly one of the most distinguished scholars of the First Amendment, and that's at 2591. So that's in the appendix to this written brief.
Well, it's all at the front page of the thing. I noticed that Robert Post is one of them.
Yes.
Who is Dean of Law at Yale until quite recently.
I mean, it's by any reckoning, it's a very distinguished group of First Amendment scholars, and we say that respectfully that their analysis is impeccable. Discrimination is directed at the protection of people. It's not directed at the protection of messages. And the useful point that they make is, but if a cake maker willingly creates and sells cakes, God bless this marriage, he can't decline to complete such a cake upon finding out that the purchaser or user is gay. And that analysis, we say, has an obvious application to the facts currently before the court.
What were the facts of this case?
Oh, it's one of the many cake shop cases that someone comes in and orders a wedding cake, and when the discovery is made that it's a gay wedding.
Just a straightforward wedding.
Yes, it is.
Yes, I see.
It is. And indeed, there are a couple other straightforward cake cases in the States where it's not about the message. And obviously, then the argument in many ways, this Supreme Court perhaps has an easier time than the US Supreme Court, which is looking at the role of artistry and issues that arise from the application of artistry, and whether that attracts First Amendment rights. Here, one is dealing unambiguously with a message. And that analysis of the First Amendment scholars is consistent with the approach of the Oregon Court of Appeals in Klein against the Oregon Bureau of Labour and Industry, and that is Authorities Volume 7, tab 102, MS 2265, that while wedding cakes of themselves are generally not expressive enough to trigger the freedom of speech protection, it would be a different case, says the Oregon Court of Appeals, if the order if the Bureau had awarded damages against the Kleins for refusing to decorate a cake with a specific message requested by a customer. God bless this marriage, for example, that they found offensive or contrary to their beliefs. And again, in hands-on originals, that is Authorities Volume 7, tab 104, relevant passage is at 2371. Nothing in the Fairness Ordinance of Lexington prohibits hands-on originals, a private business, from engaging in viewpoint or message censorship. And in a way, these American cases fit, we say, perfectly with constitutional architecture elsewhere. Some time yesterday was spent on the decision in Larimore, the Privy Council decision in Larimore, and we simply give the reference again. It's at Authorities Volume 1, relevant passage MS 285. Being required to attend classes in a room, this is the contrast with Lautze. Being required to attend classes in a room where there is a religious symbol hanging on the wall is not the same as being required to remain on parade while Christian prayers are being said. In the former case, the focus of what is happening is on the teaching. In the latter case, it is on the prayers. In the board's view, even if the non-Christians were to be excused from taking their caps off, the latter case could well be seen as involving a form of sufficiently active participation to hinder a person such as Mr. Larimore in the enjoyment of his conscientious beliefs.
Do we know, have any idea when the Oregon Bureau Klein case will come to judgment? Possibly on the last day of June.
I'm not sure if the Klein isn't the one that's coming for judgment.
It's that's not the one.
It's Masterpiece in Colorado.
It's Masterpiece. Yes, sorry, wrong case.
Splendid names. It's Masterpiece, and.
So it may be any time.
It may be, or can I, by way of a, I hope, relatively brief footnote to the discussion on compelled expression, draw attention to two cases about the meaning of political opinion. The 1973 Act is silent on what is meant by religious belief or political opinion, but Mr. Justice Kerr, as he then was in Tracy and MacDonald's application, that's at Authorities Volume 4, tab 64, MS 1356, beginning of the case, and quotation from 1374. So political opinion should be given a broad meaning. And the court will know that in terms of our constitutional prohibition, political opinion by Section 98.1 of the Northern Ireland Act 1998, political opinion and religious belief are to be construed in accordance with Article 2, 3 and 4 of FETO. and the fetal provision is at Authorities Volume 1, MS 106, MS 130 for Section 98. And that
Forgive me, Mr Attorney, what was the page reference that you gave to Mr Justice Kerr and Tracy and MacDonald?
1374.
74.
I'm sorry, Melody.
No, it's my fault.
If it's referred to in your case, it would be helpful if you could give the reference in the case.
Page 3803, paragraph 40. 39 40.
I'm grateful, my Lord.
Yes, thank you.
This provides that references to a person's religious belief or political opinion include references to supposed religious belief or political opinion, and the absence or supposed absence of any particular religious belief or political opinion. And any reference to a person's political opinion does not include an opinion which consists of or includes approval or acceptance of the use of violence for political ends connected with the affairs of Northern Ireland, including the use of violence for the purpose of putting the public or any section of the public in fear. And the concept of political opinion in Northern Ireland it has been fairly uniformly held, much further than the political views connected to the traditional green-orange divide that might, in the abstract, reasonably have been thought to have initially given rise to this rare form of constitutional protection. So it's very rare. I've drawn attention that in Scotland there is no explicit limitation in terms of religious belief or political opinion, but even if there were to be, and one finds in other parts of the world, protection against discrimination on religious grounds, discrimination on the ground of political opinion, well, of course it's there in Article 14 of the Convention, really doesn't find expression in too many constitutions. I suppose the obvious point being is that politics is about discrimination on the ground of political opinion. That's the political process. And what one can detect sometimes in some of the judgments, a concern that the idea of political opinion is just a little too protean and hard to get a handle on. This first crystallised in the decision of the Northern Ireland Court of Appeal in Mackay, which is AV4, Authorities Volume 4, tab 68, and certain material, one sees at MS 1458 to MS 1459, the court looks at some of the background materials, including references to the Van Straubenzee report, and held that there was no valid ground on which to confine the term political opinion to the unionist nationalist divide traditional in Northern Ireland. That finding is at MS 1461. And the court held that if it had been the intention of Parliament to restrict the term political opinion to unionist nationalist politics, those words could simply have been inserted into the Act to make this clear. MS 1462. And Lord Justice Kelly, who is glowering down at me as I speak, held internal pagination 117, MS...
Glowering at you.
Maybe it's simply my
anyway, of whose presence you are conscious as you speak.
Well, maybe I speak from paranoia and better experience as a first-year barrister. With 1463, that political opinion means, in broad terms, an opinion relating to the policy of government and matters touching the government of the state. And it's also clear from McConkie, and that's Authorities Volume 3, tab 51, MS 1004. 1004.
Yeah.
And there's a helpful synthesis of Lord Newberger, paragraph 68 to 69, MS 1021, 1022, that but for the exclusion of approval or acceptance of the use of violence for political ends from the statutory definition of political opinion, such an approval or acceptance would have been properly regarded as a political opinion. And I hope I may be forgiven for expressing the view that the concept of discrimination on the ground of political opinion may be an example, as the materials in Mackay might tend to suggest, of a gap between parliamentary intention, or at least parliamentary expectation, and the meaning of the words enacted by Parliament. It does seem that one goes back and looks at the materials considered in Mackay, that there was a desire to weave in protection against discrimination on the ground of political opinion with religious belief in the two communities in Northern Ireland. But if that was the intention of parliamentarians, it certainly didn't find expression in the term that they used. But interestingly, the exclusion with respect to support for the use of violence is limited to the affairs of Northern Ireland. So if one has a view about the legitimacy of violence in any other context, and one is refused service on that ground, then one can maintain an action under veto. But if one once held a view about the legitimacy of violence in Northern Ireland, then one can quite freely, in terms of exposure to civil liability, refuse service to such a person. So, my ladies, my lords, that takes us to part 4 of these submissions and the liability creating provisions. And I hope to move through this fairly quickly. Can I make 3 preliminary points about them? Firstly, and obviously, both veto and SOR are examples of subordinate legislation. Secondly, the expressive issue, as has been ventilated yesterday and today, isn't analysed in any of the travaux préparatoires. And thirdly, it's the nature of these instruments that it wouldn't have been possible to have amended them during the course of any parliamentary debate. So, beginning with veto. Veto was made pursuant to the law-making power in paragraph 11B of Schedule 1 to the Northern Ireland Act 1974. And what has that? Tab 17 of Volume 1. Veto is directed against discrimination on the ground of religious belief or political opinion, and by Article 3.1, Authorities Volume 1, MS 108, discrimination means discrimination on the ground of religious belief or political opinion, or discrimination by way of victimisation. And Article 28.1 of veto, MS 111, it is unlawful for any person concerned with the provision for payment or not of goods, facilities or services to the public or a section of the public to discriminate against a person who seeks to obtain or use those goods, facilities or services, A, by refusing or deliberately omitting to provide him with any of them, and so on. And we know that the power to make veto was subject to the limitations created in Section 17 of the Northern Ireland Constitution Act. Again, for the note, it's MS 166. As a result, if any provision of veto discriminates against any person or class of persons on the ground of religious belief or political opinion by treating, and this is the definition supplied by Section 23.1 of the 73 Act, that's MS 167, any person or class of persons less favourably in any circumstances than those persons are treated in those circumstances by the law for the time being in force in Northern Ireland, then that provision is void to the extent that it does so. And I've given the Court the reference to Daly and others, where one sees an example of that worked by Lord Justice McDermott. The unhelpful MS number is MS 4209. That takes us to the Equality Act, Sexual Orientation Regulations, SOR. SOR were made, as the Court knows, during a period when the Northern Ireland Assembly was suspended and no Northern Ireland ministers accountable to that Assembly were in office. Section 82 of the Equality Act permitted the office of the First Minister and Deputy First Minister to make regulations within the scope of SOR. And one sees the explanatory memorandum for that Act at Authorities Volume 1 and dealing with 82, Section 82, it's at MS 65. And Regulation 5 is the one at issue here. The Court finds that at MS 30. It's been canvassed already. I won't read that to the Court. And of course, although there was a specific tasking or empowering by the Equality Act 2006 to make provision about this form of discrimination, it is subject to the limitation in Section 24 1C of the Northern Ireland Act 1998. And so if any provision of SOR, as applied, is incompatible with any of the Convention rights, such provision would also be ultra vires by virtue of Section 24 1A. And that's a bridge by which we end the fourth part of these submissions and move to compatibility with rights protected by the Convention. So, in terms of SOR, the Office of the First Minister and Deputy First Minister was limited, as we've seen, in its lawmaking powers by Section 24 1A. It could not make any regulation which was incompatible with the rights protected by the Convention. So if Regulation 5 in its application is incompatible with the Convention rights, one of two things happens. Either the application isn't a valid application and is so held, or if that can't be avoided, then the regulation, provision of the regulation is pro tanto void. In my submissions on the role of the Convention, I want, with apologies, to start by stating the obvious. The Convention must be read as a coherent and harmonious whole. And the standard authority for that, it's a line that one finds throughout the Convention jurisprudence, but conveniently it's in Schalk and Kopf against Austria, and that's Authorities Volume 5, Tab 82, MS 1813, paragraph 101. And in the context of this reference, this must mean that a necessary aspect or consequence of being free to think and believe, which is protected by Article 9, must be being free not to express views inconsistent with those thoughts, and for surely not to be forced to express views that are dramatically inconsistent with those thoughts, also protected by Article 10. A second statement of what I hope is obvious is that I found myself here on the approach of this court in RT Zimbabwe against the Home Secretary, Authorities Volume 3, Tab 43, MS 741, and that is, albeit in a different context, and adopting the words of Lord Dyson at paragraph 42, nobody should be forced to have or express a political opinion in which he does not believe. Lord Kerr's reference, paragraph 76, MS 749, to the right not to hold a political opinion, to which we would again add the right not to have to express a political opinion. Compelled speech will always, in itself, be regarded as problematic in Convention terms. And in paragraph 57 of our case, MS 3088, we make reference to a film with theological content. So, if in some future dystopia one were obliged to express any aesthetic judgment about Eric Romer's Manui Chez Maud, that would be problematic in and of itself in convention terms. But if one were asked to express a view about Pascal's Wager, the central theme of that film, that would be even more problematic in convention terms, because that's a matter which goes to the core of theological speculation and belief. So, beginning with Article 9, of course a commercial service provider is subject to the prohibition set out in Regulation 5 of SOR. But the provider does possess and can avail of the freedom to manifest a religious belief in practice and the right to his or her opinion by refusing to express a political opinion which is contrary to that religious belief, albeit that the demand to express it comes as part of his or her service. And Article 9 is thereby engaged. Engagement of Article 9 was accepted, we say correctly, by the Court of Appeal, and inevitably in view of the approach of the Strasbourg Court in Ouida. See paragraph 108 of that decision at MS 1742. And of course, the decision to engage in service provision in the knowledge of SOR does not mean that the protection afforded by Article 9 is lost. And the Court has my point in relation to the global difference between the cakes advertised in colour and that which Mr. Lee asked them to bake or to produce. Of course, Article 9 is one of the qualified rights and can be justified in order to protect the rights of others, but there is no convention right to a non-essential service from a particular commercial supplier. The possible embarrassment and the likely inconvenience of being refused service, having regard to the absence of any right not to be offended, does not seem, in the absence of some specific aggravating feature entirely absent in this case, to appear to reach the required level of seriousness as to engage Article 8. But even if obtaining a service were to be regarded in some way as a right for the purposes of justification of any interference with the right to manifest a religious belief in practice, or to avoid being compelled to express a view inconsistent with that religious belief, it doesn't weigh heavily in the balance, we say, given the importance of protecting citizens against compelled political speech. There is no objective and reasonable justification for the interference with the right protected by Article 9.1 in a context where liability is imposed for a refusal to express a political opinion which is at odds with the political opinion or religious belief of the person compelled to express it. A right not to express a political opinion can be derived from Article 10, and here we see the key authority as being Goodwin. Goodwin is, as the court knows, the journalist source case, and the court itself doesn't say anything explicit on this issue. The holding in paragraph 39, an order of source disclosure, MS 1955, does, however, seem clear. So what is at issue is an order of source disclosure. By implication, the journalist wishes on this issue to remain silent. And very helpful here too is the view of Judge Walsh in dissent in terms of his analysis of what's happened in the decision. And he says about the applicant, paragraph 2 of his dissenting opinion, MS 1963, he has refused to speak. And the Grand Chamber in Gilberg left open the issue But what we say is that insofar as the court considers, and it would be unlikely in terms of its decision in RT Zimbabwe, this is the position, that there hadn't yet been a crystallisation around the right not to speak, we say nonetheless it would flow naturally from the existing Strasbourg jurisprudence for the court to find that there was clearly protection in Article 10 against being compelled to speak. I draw attention very, very briefly to what Lord Brown says in Rabone, now a very classic passage, MS 789, and then simply into the again, also a very classic passage now of Lord Wilson in Muhan, paragraph 104, 105, Authorities Volume 2, MS 456, 458. And in particular, he notes Lord Kerr's opinion in Surrey County Council that the court is required to determine whether an alleged right exists even where the jurisprudence of the European Court of Human Rights discloses no clear answer. And on this, relevantly and very recently, we draw attention to what Lord Kerr says in the DSD case, Commissioner of Police of the Metropolis against DSD, Authorities 1, tab 23, MS 206, paragraph 79. And in Muhan, paragraph 105, Lord Wilson says this, MS 458. At any rate, where there is no directly relevant decision of the European Court of Human Rights with which it would be possible, even if appropriate, to keep pace, we can and must do more. We must determine for ourselves the existence or otherwise of an alleged convention right, and in doing so we must take account of all indirectly relevant decisions of the European Court of Human Rights, and in particular of such principles underlying them as might, whether as currently expressed or as subject to the natural development apt to a living instrument, inform our determination. Again, to the extent that this is necessary, we respectfully agree, and one can see a corpus of indirectly relevant decisions in the, one can broadly call them the trade union cases under Article 11. And if one looks at Sorensen and Rasmussen, there is a useful statement by the Grand Chamber of General Principles, paragraph 54, Authorities Volume 5, MS 1859. The protection of personal opinions guaranteed by Articles 9 and 10 of the Convention is one of the purposes of the guarantee of freedom of association. Such protection can only effectively be secured through the guarantee of both a positive and a negative right to freedom of association. And again, the court would be familiar with Young, James and Webster against the UK, Authorities Volume 6, tab 93, MS 2083. And the facts are certainly in Sorensen and Rasmussen are useful. Both applicants were compelled to join a particular trade union, and the court found that that struck at the very substance of the freedom of association guaranteed by Article 11, MS 1863. Now, the Sorensen Grand Chamber decision followed the earlier trade union case we've seen, Young, James and Webster, where the court found, paragraph 65 of the judgment, MS 2081, that the legislature, though passing legislation protective of rights, hadn't reached a proper balance between the conflicting interests of those involved and thus acted incompatibly with the Convention. And in terms of possible justifications, one draws attention to the importance of freedom of expression. An important reference here is Bedat against Switzerland, Authorities Volume 5, tab 78, MS 1696, going to 1697. a useful statement of general principles at paragraph 48. I won't read that out. But I will draw attention to the next paragraph at 49. As regards the level of protection, there is little scope under Article 10.2 of the Convention for restrictions on freedom of expression in two fields, namely political speech and matters of public interest. Accordingly, a high level of protection of freedom of expression, with the authorities thus having a particularly narrow margin of appreciation, will normally be accorded where the remarks concern a matter of public interest. And useful both as a finding, but also in terms of the facts which it offers for analysis, is the recent Chamber decision in Stern Tollats and Ura Capalera against Spain. That's the Authorities Volume 5, tab 77, 1663, in particular paragraph 36. Unfortunately, the judgment is available only in French, but there is a press summary at the end. But it's a fascinating case in a sense, in a number of ways. The applicants were imprisoned in default of paying a fine because they had protested vigorously against the visit of the Spanish king to Catalonia, and 300 years of Bourbon is too much. Spain, get out of Catalonia. A clear finding of breach of Article 10. And I said that the factual context of that case is useful. It is for this reason, because it provides the opportunity to analyse or speculate usefully, I hope, as to what the court might have done if Spanish law had compelled citizens of Spain, whether in Catalonia or elsewhere, to shout Viva el Rey as the monarch passed by. And unthinkable that form of compelled speech would not have been regarded as objectionable in Article 10 terms, but also, given Catalonia's history, to have to express in Catalonia the last Habsburg supporting part of Spain in the War of the Spanish Succession in respect of a Bourbon monarch would be regarded also as attracting Article 14 protection. And the UK trade union cases, Aslef and Redfern, again, are directly relevant. They are almost the counterpoise of each other. In Aslef, it's the trade union that objects to having to keep on a member whose political views are utterly at variance with those of the organisation, or pay damages to him for expelling him. And Redfern is an example of the court finding that the UK's regime for protection against dismissal on the ground of political opinion is insufficient to secure convention compliance. And they're useful cases, but in a way the examples could be multiplied, because it is impossible to imagine a case of compelled expression where the content whose expression is compelled has a political message, a strong political message with, as here, clear theological implications, passing muster in convention terms. There is no authority, certainly no authority that I have found, that lends the least comfort to such a compelled expression being survivable in convention terms. Again, Article 14 may also be in play. Plainly, one is in the ambit of 9 and 10. And here, the disparate impact, depending upon the religious belief or political opinion of the party whose speech is compelled, is inevitably a matter of some importance. Typically, of course, one knows that there are a lot of Strasbourg cases where, although Article 14 is plainly properly in play, the court simply declines, having found a substantive breach, to go further and to deal separately with it. If I can take the court back briefly to the impression that Mr. Justice Weatherup, as he then was expressed in the Christian Institute case, Authorities Volume 3, tab 53 at MS 1071, that they didn't, these regulations didn't treat evangelical Christians less favourably than others. There was a particular context to that, because one knows that at MS 1071, that the judge was told that there was nothing in SOAR that would prevent an owner of accommodation requiring that those sharing accommodation be married. And that's paragraph 90 of his judgment at MS 1071. And of course, obviously we know, following the decision of the House of Lords in Bullen Hall, that that context no longer applies. In a case, in convention terms, involving compelled expression of political opinion, the relevant comparability for Article 14 purposes is simply that of between A, those who oppose the opinion that they are required to express, and those who support the opinion that they are required to express, or those who oppose the compelled expression and simply those who do not. Obviously, both for justification under Article 14 and for proportionality in terms of Articles 9 and 10, the court will apply the four-stage test in Bank Mellet, paragraph 20, MS 531. And we say it is, of course, a legitimate policy choice to extend protection against discrimination to the field of, in the field of goods, facilities and services, to sexual orientation, to make sexual orientation a protected ground in the field of goods, facilities and services. It is not a legitimate choice to compel citizens to express views which are not theirs and to which they object on grounds of religious or political opinion. And in fact, the legislative choice taken domestically in this jurisdiction is that the legislature, in enacting the 1973 Act and the 1998 Act, has given a higher value to protection against compelled religious or political expression than the protection that exists in the two subordinate instruments, veto and SOAR. Secondly, there is no rational connection between the legitimate policy choice to extend protection against discrimination to sexual orientation in goods, facilities and services and compelled expression. Compelled expression stands quite apart from a protection against discrimination. But even if there were to be regarded as such a rational connection, then, and making due allowance for legitimate choice of means, imposing compelled expression as the cost of protection against discrimination on the ground of sexual orientation is so very far from the least intrusive as to fall at this third stage. Because the final question, one of fair balance, and helpful here is Lord Mance's approach in the Welsh reference, the Asbestos Diseases Wales Bill, Authorities Volume 2, tab 34, MS 393. And he says at the fourth stage of the convention analysis, all relevant interests fall to be weighed and balanced. That means not merely public, but also all relevant private interests. The court may be especially well placed itself to evaluate the latter interests, which may not always have been fully or appropriately taken into account by the primary decision maker. Now, that might be thought to apply more particularly where one is dealing with a concrete case, and one is not dealing with a concrete case in my reference, albeit that it's informed by the facts of a concrete case. But it's worthwhile.
We weren't doing that in the Welsh case either.
Precisely.
Which is no doubt why you're using that rather than several other examples of exactly the same thought that you could have used.
Indeed. Your ladyship has completely anticipated me. So that's exactly. So it's an abstract reference. It's the bare flesh of a legislative text. One doesn't even have the advantage in such a reference of a worked example, such as Lee and MacArthur provides. That's rather a selfish view. Provides for me in this reference. And of course, while legal certainty and a workable general rule are important considerations in terms of fair balance, they have a different rule where what is at issue is not in fact a general rule. For example, in relation to pensions, the general statement of a qualification or restriction, but what is a liability creating provision, which always requires application, where the court will always be engaged in an assessment of whether the relevant statutory test is met. And therefore, merely because it is of course desirable to have general rules, and general rules will sometimes yield satisfactory results from the individual perspective, a different approach when we say is required when what is at issue is not a general qualification rule, for example in relation to pensions, but what is a liability creating provision. And we say that should Regulation 5 of SOAR impose civil liability for refusal to express a political opinion contrary to religious belief, then a fair balance has not been struck. Regulation 5 is void insofar as it can be used, as it was in Lee and MacArthur, to compel, on pain of civil liability, a political expression contrary to the religious belief or political opinions of those compelled to express it. Now, I turn sixthly to the issue in the second reference, the fourth question posed, and that is the addresses the temporal application of paragraph 33 of Schedule 10 to the Northern Ireland Act 1998. And just so that it's all there, the court has all of Schedule 10. It has Schedule 10 already in 2 bits, but it has all of Schedule 10 in the sheaf of documents we put before the court this morning. It's the 3rd tab. But in terms of MS numbers, paragraph 33 of Schedule 10 is at MS 133, and there one reads: the Attorney General, the Advocate General for Northern Ireland, the Attorney General for Northern Ireland, or the Advocate General for Scotland may require any court or tribunal to refer to the Supreme Court any devolution issue which has arisen in proceedings before it to which he is or they are a party. And there are some useful documents that the court will need to look at in some detail. There is the ruling by the Court of Appeal on this issue and others of the 22nd of December 2016. That's the core volume, Appendix Part 1, starting at MS 3226. 3226. And that runs to 3228. And the Court of Appeal declined to make a reference under paragraph 33 following service of a notice by me shortly after judgment had been given in Lee and MacArthur. Judgment was delivered in on the main issue on the 24th of October 2016, as the court knows, and one finds that just in the immediately preceding pages. That's MS 3194 and following. And if one looks at paragraph 6 of the ruling of the 22nd of December, that's MS 3226, one sees the history. Judgment in this case was given on 24th of October 2016 by virtue of Order 42, Rule 8 of the Rules of the Court of Judicature. The judgment took effect from the date on which it was given. Thereafter, it had to be signed, sealed and filed. On Friday, 28th of October 2016, the Attorney-General lodged a notice requiring the Court to refer the devolution issue which had arisen in the proceedings to the Supreme Court. The judgment was sealed and filed on Monday, the 31st of October 2016. So, in fact, the position was even a little more complicated than that, and one sees that in tab 1 of the additional appeal documents. The MS page is 4135. It's the very first document in that additional appeal documents bundle. No, it's not. It is the official additional appeal documents with, as we've now gathered, unhelpful MS numbers.
Yes, but tab 1 is your additional note, your further note.
It is. And it begins with a chronology. 24th October, judgment given. On the 27th, signed a notice. Well, nothing effective in that. Hasn't come to the court. And the original notice was hand-delivered to the central office in the morning of the 28th of October. And a review of the case took place on the 22nd of November, and the court advised that it had made an order in the case on the 24th of October, and on my understanding that the order was finalised on that date, I accepted the court was no longer in a position to comply with the notice under paragraph 33 because the order was final and the requirement under paragraph 33 had come after the final order in the case. In fact, as this court will appreciate from paragraph 6, MS 3226, the order hadn't been made up until the 31st of October. So between the judgment and the order, a valid notice had been made. A valid requirement under paragraph 33 had been lodged with the court. Now, how does the Court of Appeal deal with this? Paragraph 7 of the Court of Appeal judgment, MS 3226, draws attention to paragraph 33 and 34, and it was submitted that because paragraph 33 referred to any devolution issue which has arisen in proceedings, the reference to the past tense indicated that the referral could be made at any stage. We do not accept that interpretation because the phrase proceedings before it, to which he or she or they are a party, requires that there are such proceedings ongoing at the time of referral. There is no doubt that the court can recall and vary an order before it is perfected, and indeed there is authority to suggest that an appellant court can do so even after perfection. Taylor and Lawrence. It is clear, however, that such a power should only be exercised in highly exceptional circumstances. The fact that there is such a power does not mean that the proceedings in which judgment has been given are ongoing, and we do not consider that there are exceptional circumstances in this case which require us to reopen the proceedings. We are also not inclined to accept that the signing, sealing and filing of the order constitutes a proceeding. That approach is supported by Dayton and Cockle, where the court held that signing judgments under the old Order 14 was not a proceeding within the rule. In our view, the proceedings ended with the giving of judgment and have not been reopened. Accordingly, we do not consider that the Attorney-General has power to require the court to refer under paragraph 33 of Schedule 10 to the Northern Ireland Act, because at the date on which he purported to refer, there were no longer proceedings before it. That accords with our view that the power to require the court to refer is designed to enable the Attorney-General to refer proceedings in which he is involved prior to judgment, so that the Court of Appeal can determine the case with the benefit of the opinion of the Supreme Court. Once judgment is given, the Attorney-General has the appeal rights of any other litigant and can also exercise his powers under paragraph 34. The court has no role to play in relation to the exercise of those powers. And in conclusion, can't use paragraph 33, and there's an addendum. Subsequent to the delivery of this determination, the Attorney-General submitted that we should in any event refer under paragraph 33 of Schedule 10 the issue whether there was jurisdiction to require this court to refer the matter to the Supreme Court. That was a submission he had made in the course of the earlier hearing. In our view, the same principle applies. There is no proceedings before the court to which that application can attach. The Attorney-General may want to use the paragraph 34 powers to raise the issue indirectly with the Supreme Court, but that is a matter entirely for him. Now,
So can you raise it, under the ordinary right of appeal? Is that right?
Or paragraph 34 is a free-standing reference, which doesn't involve any court inferior to this court. It's a reference of a devolution issue. But then, if one goes back, and we can see the argument placed before the court.
Well, that's an interesting question. It's not challenged that you have the right to do it under paragraph 34.
No, it's not.
No.
But of course, you want to do it in these proceedings.
I do.
Because you want these proceedings to have a different outcome from the one.
I do. Yes.
That's why you're doing it this way.
Yes. Yes. Well,
Oh, deeper reasons than that.
Well, I would have liked, because that's an option that's not open to me. I would have liked to have done that because it struck me, and again, this is a point which we make in the submission that was before the court when it decided that, and it's the MS 4138, the penultimate page of the further note. Alternatively, and to ensure that the rights of all of the parties to this appeal are preserved, if the court doubts whether it can refer the questions contained in the notice delivered on October 28, then the court should refer the following question, which is a version of the question that's now before the court. Now, the court's rationale was, oh no, we want to be informed by the judgment of the Supreme Court. So once we've given our judgment, there's no point referring, and there are no proceedings.
Is there any precedent for a court of appeal, a situation arising where a court of appeal will be told by a higher court what it should do in those proceedings?
Well, that's
the objective that the Court of Appeal is suggesting that the provision has does seem quite unusual.
Yes, respectfully agree. And indeed, it's a rationale that the court itself, as 4 members of this court will recall, the court itself undermined, because in the Human Rights Commission case, the unwilling to get caught a second time this way, a notice under paragraph 33 was lodged with the court. The court accepted it, but then proceeded to duly reflect, deliberate, and produce the 3 judgments of the respective Lord Justices that are obviously under consideration by 4 members of this court now. So the court instantly undermined its own approach. But my approach is to interpretation is that there's every good reason why the court might want to express its own view, the Court of Appeal might want to express its own view on a subject, and I don't criticise the court for having expressed a view on the questions that were then before it in the Human Rights Commission case. And indeed, as this court knows in the Brexit litigation, in Miller and others, Mr. Justice Maguire had delivered his judgment and then referred the questions. And the court...
Isn't there a sort of analogy in the references made to the European
Well,
Court of Justice?
I was thinking that, yes.
You give judgment and say, but we need further guidance as to whether we're correct.
Yes, respectfully agree. And of course, that can happen. The court can give its view or can refrain from expressing any view. And one sees, the only thing that matters is that the court hasn't finally devolved itself of its relevant function.
Can I ask, the Court of Appeal, sorry. The Court of Appeal thought that a case called Dayton and something was of relevance. It doesn't seem to be even in our bundle.
No. Well, the reason why it's not, because in one sense, it is the ministerial act of drawing up the order of proceeding. No. I mean, in a way, the court has created a bit of a straw man there, because no one was arguing that there was any significance in the purely ministerial or administrative drawing up of the court order, that itself wasn't a proceeding. But if the question is asked, stepping back a bit, well, were proceedings still ongoing? Well, we know that they were, because the court had adjourned the issue of costs. We know that, in fact, the court was, let's not use the word proceedings as maybe forensically loaded, but the court was certainly entertaining a debate about the extent of the paragraph 33 powers. And the court was addressing the issue of the consequence of the notice having come between judgment and order.
Do you accept the Court of Appeal's view that there must be continuing proceedings for the power under paragraph 33 to be exercised?
Our submission on that is that the proceedings must not have been finally determined. Hence, whenever...
Let's just look at paragraph 33. May require any court to refer to the Supreme Court any devolution issue which has arisen in proceedings before it to which he is or they are a party. Is it by reason of the present tense he is or they are a party that you make that concession?
Well, the concession is once the proceedings have come to a definitive end, that is by the sealing of the order. I couldn't, for example, even in cases in which I had been a party, let's dredge the back office.
Well, let's just examine why you're making that submission. Any devolution issue which has arisen in proceedings. Now, if you stopped it there, it's at 133.
Yes.
The Attorney General may require any court to refer to the Supreme Court any devolution issue which has arisen in proceedings before it. Would you say that it wouldn't be open to you if the final words of paragraph 33 were not present? Would it have been open for you to ask the Court of Appeal to refer it to us, or require indeed the Court of Appeal to refer it to us, notwithstanding that they've completed?
Well, my submission is firstly, when the notice under paragraph 33 was given,
yes, I appreciate
the court was required to refer.
Yes, but I'm just wondering why you're making the concession.
Oh no, but my concession, the concession which I made and don't, in one sense, reside from was that when I was told that the order's already been made and it was made on the day of judgment, then it transpired that wasn't accurate. So therefore, when I
appreciate all of that, Mr. Attorney. I'm just trying to get at the reason that you've made the acceptance that you did. Because if the final words paragraph 33 were not present, and one stopped at which has arisen in proceedings before it. Surely it would have been open to you to argue that a devolution issue has arisen in proceedings before
Well, and I do continue to argue that it had arisen in proceedings before the court.
But is it therefore the final words which prompt your concession?
No, because they add nothing in a sense, because one is a party, albeit that the present tense is used with respect to that. But in one sense, am I a party in case X? If case X is over, then I may say that I was a party in case X.
They add something. I mean, they add the idea that you are trying to, by the reference, to affect the result of proceedings to which you are currently a party.
Yes.
If the proceedings are over, you've lost. And your remedy is to appeal, isn't it? Rather than make a reference.
Yes. Respectfully agree. I mean, there might be other appellate proceedings, if one imagines High Court, Court of Appeal.
But once you've lost, it's too late to make a reference.
It is.
But
the question is at what stage have
course,
proceedings
when have
come
you
to an
lost?
end?
When have you definitively lost? And you say, certainly not until it's too late to affect the order.
Yes. When the Court of Appeal, obviously no suggestion, of course, it was simply one of those things, but the occurrence of one of those things, the administrative making up of the order when a valid notice had issued under paragraph 33 shouldn't undermine the constitutional right that exists in paragraph 33. So the court shouldn't have stood behind the administrative making of the order on the 31st October. It should not administratively have been made when a reference was made.
But you don't submit that when it received a valid notice before the order had been finalised, it ought not to have allowed the order to be finalised?
Respectfully agree, Lord. Yes. Yes.
Your position.
It is. It is. Respectfully agree, Lord. Yes. So that it shouldn't have occurred, and therefore the court was wrong to stand behind that and accept that as a. I'm just wondering
what the effect of making a valid application to the Court of Appeal might be. I mean,
well,
you say that the Court of Appeal shouldn't have stood behind it. Could a valid final order be made once you had made your application?
We would submit not, but obviously one speaks with hesitation of validity in the context of the High Court and Court of Appeal being courts within the jurisdiction, but certainly it wasn't properly made, if one can put it that way.
Should it be set aside?
And I mean, it's irregularly made before it's completed, had the result of the reference.
Well, the slip rule is designed it's classic case for application of the slip rule. But well,
I mean, I think the difficulty about the application of the slip rule is that the court has to be minded to have to it.
Yes, but
I think my Lord's point is an anterior one and a rather more fundamental one, and that is, if the court, by dint of the receipt of your notice of application, was, at least if the court in general, I'm not talking about the Court of Appeal, also the administration, it did not have the power to finalise the order, then it's a question of our being invited to declare that the making up of the order was in effect a nullity.
Yes, Lord, with the hesitation, of course, that those are terms that one shrinks from using in the context of the Court of Appeal.
The old terminology, ex debito justitiae,
yes.
automatically
Indeed,
as a irregularity.
Yes. Respectfully agree. And if one looks at what is said in Order 120 about this, this is MS, Authorities Volume 1, MS 161. It's actually clear in terms of what the court's obligations
Sorry,
are.
could you give me that reference again?
Yes, it's Order 120, Rule 8. It's Part 4 of Order 120. It's MS 161. Part 4, heading references to devolution issue to the, again, the dates, the story, Judicial Committee. 8.1, where the Court of Appeal decides in accordance with paragraph 9 of Schedule 10 to refer devolution issue to the Judicial Committee, or the High Court or the Court of Appeal in accordance with paragraph 33 of Schedule 10 is required by the Attorney General for Northern Ireland, to the appropriate Minister or Department to refer devolution issue to the Judicial Committee, the Court shall make an order which shall include a schedule setting out the devolution issue, referring the issue to the Judicial Committee.
And look at 9.
Yes. Indeed.
Yeah.
So, for example, the path before the court, we say respectfully, was clear. And again, realistically, we quite understand that the court might not have liked the reference, might not have liked the timing of the reference, but there is power to make rules which could regulate prospectively when such references would be made. But the court doesn't grapple with Rule 8 at all. And it seems, respectfully to me, to be absolutely clear that there was a valid reference. The validity of the reference is not contested. The proceedings were not at an end. There was still business to do, costs most obviously, and then the entertaining of an application for permission by my other friends. And it seems to be in one sense it is a straightforward case. And we've gone through in our printed case a number of the authorities, but again the decision, and of course the approach may well be particularly sensitive in family law cases, but this court has given really the clearest possible guidance as to the distinction between judgment and order.
I don't recall that case was limited to family cases.
No, but again, I won't come back with a ready reference, but I do seem to recall, obviously, the particular importance in family cases of getting it right. But one might add, particularly important in constitutional cases to try to get it right and to avail of the extant constitutional machinery. So it seems to me that it really couldn't be clearer in our respective submission. And my other friend criticises me and says, "Oh, well, I should have waved a stop sign in front of the court and told it, don't do anything, don't make up an order." But the filing of a valid notice is a stop sign.
Well, are we on to the answers to your questions?
Yes, obviously there are a whole lot of authorities that were canvassed in that section of our printed case, if the court desires me to open them. But it strikes me that given the approach that this court has already taken, given the clear language of both paragraph 33 and Order 120, that it's absolutely clear what the court ought to have done. And indeed, as I've indicated, the court's own rationale, it itself undermined a few months later by proceeding to deliver judgment afterwards. And a good thing too, it enormously assisted this court's consideration in the Human Rights Commission case. And again, it was found to be, albeit no one objected to it, this court in Miller and others looked at it and again was immeasurably assisted by the judgment of Mr. Justice McGuire. So, yes, I'm grateful that I was going to take the court to our proposed answers. And before I do so, can I perhaps express this last thought that given the assistance that this court will have obtained from the judges of the Court of Appeal in the Human Rights Commission case, given the assistance that was afforded to this court in dealing with the Northern Ireland issues by the decision of Mr Justice Maguire, if it became a finely balanced interpretive choice, and we say it's not, it's much clearer than that, but if it were to be regarded as a finely balanced interpretive choice, then the interpretive choice ought to come down in favour of that which permits a proper dialogue between the Court of Appeal and the Supreme Court. So, turning then to conclusion. There is a debate, of course, about what is sometimes called reasonable accommodation, where one attempts to reconcile conflicting rights. This actually is a case not so much of reasonable accommodation or of conflicting rights, but where the answer, we say, under Northern Ireland constitutional law is absolutely clear, where the rights are already harmonised. Mr Lee is perfectly entitled to go into Ashers, as he indeed did on at least one occasion previously, and buy a cake. And any attempt by Ashers to deny him service on the ground of a sexual orientation is not only reprehensible, but is subject to civil liability by virtue of Regulation 5 of SOAR. But on the analysis that we offer, Mr Lee doesn't have the right to compel Ashers to express a message, to deliver content which is inconsistent with their religious beliefs or political opinions. Nothing in Northern Ireland constitutional law puts someone in the position of the MacArthurs in a position where they must choose between either being the conduit or courier of a message to which they object on the ground of religious belief or political opinion, or exposing themselves to civil liability. What is, of course, the context for this reference, the Ashers litigation, but the argument that I present in this reference does not favour one theological or political view over another. Our argument is simply that compelled expression against the religious or political belief of the person compelled to so express is contrary to Northern Ireland constitutional law. And towards the end of my learned friend Mr Allen's submissions yesterday, he made great play of the objection to the word gay. And of course, 2 points about that. The objection wasn't to the word gay in isolation. The objection was to the word gay in a specific message: support gay marriage. And Mr Allen invited the court to conclude, gay, what else does it mean but sexual orientation? But, my ladies, my lords, there is a fundamental conceptual distinction between objecting to utter a word, and in particular a word forming part of a message, and objecting to serve the person who uses that word to describe himself. They're not the same thing. and it is impossible, in our respectful submission, for Mr. Allen to bridge the gap between the word in the message, and the person. We know, as far as we know anything, that the person would have been served. Mr. and Mrs. MacArthur only too happy to supply Mr. Lee with cakes. The objection was only, and narrowly only, to the message on the cake.
Insofar as you're making submissions on the actual case, I don't know whether that's your prime role, but there might be said to be a point which arises from the district judge's approach, which, in summarising, if I summarise it, it was as follows, that as regards the point on sexual orientation, the objection was the message, that's paragraph 43, but as regards religious belief and political opinion, the objection was to the person bearing the message, paragraph 68, although she also says that if she had been persuaded that the MacArthurs were not aware of Mr. Lee's religious belief or political opinion, she would have found indirect discrimination, which implies that the cake would still have been refused, which means that it would have been refused on the grounds of its message only. So there is a point as to how we deal with that. On the face of it, it seems somewhat contradictory to find in relation to sexual discrimination that what mattered was the message, but to find in relation to religious belief and political opinion that what matters was the individual bearing the message, but while at the same time finding that if the individual had been simply a courier, the cake would still have been rejected because of the message. So, I mean, maybe we just simply have to make up our mind as to what the real point is, whether it's the message or not in relation to both.
Well, that's the advantage of this reference, that one can draw on the facts insofar as one finds them useful to illuminate the problem, but what one needn't be unduly trampled by them, and therefore, I make no apology for drawing on the fact that as useful to explore, but specifically, may I say that the issue of indissociability, of course, is much clearer with respect. If I come along, yes, of course, there's the possibility of a courier, but if I come along and say, look, I'd love to express this message, could you do it?
Yeah.
And it's a political message, well, then that seems fairly readily indissociable from me, just as, but stronger in relation to compelled speech, but I can't say that because I am profoundly in disagreement with that on the ground of my religious beliefs or my political opinion. But from my perspective, what matters is that the Northern Ireland legislature, here dealing with subordinate legislation and making veto, could not impose a liability generating provision, couldn't make a liability creating provision that ever penalised someone for their religious belief,
Yes.
political opinion.
So there are two ways of looking at it. Either we accept your indissociability argument in this context, but say if you're right that that couldn't be, the legislation makes it impossible to reject the, to condemn the rejection as discriminatory, or one could say that in this situation the reality is that the message is separate from the messenger, as tested by the example of the courier, and that the real objection is to the message.
Yes,
Yeah.
and of course, when it becomes just the message, then it's simple.
Yeah.
I mean, it's simple, and one doesn't get perhaps to the answers that I'm proposing. But if one can't wriggle out of that then in relation to veto. I mean, in a sense, SOR is easy because the hierarchy is so clear in Northern Ireland constitutional law. In veto, one is dealing with two forms of protection. So Mr. Lee has a right not to be discriminated against on the ground of his religious belief or political opinion. His political opinion, we know, is very much in favour of gay marriage, hence the message on the cake. The MacArthurs, however, have the higher protection in Northern Ireland constitutional law in that no provision can create liability and impose a burden on them of having to say something to which they object on religious or political grounds. So, may I say that...
Let's get to the 4 questions.
Well, yes.
Because you've 10 minutes.
Oh, thank you, Lily. Well, I won't need all of them, obviously, to propose the answers. So, in relation to the first question, the court is asked to confirm that in light of the prohibition of discrimination on the grounds of political opinion or religious belief that is contained in section 24(1)(c) of the Northern Ireland Act 1998, there was no power to make, confirm or approve Regulation 5 of the Equality Act, Sexual Orientation Regulations, Northern Ireland 2006, insofar as that regulation imposes civil liability for the refusal to express a political opinion or to express a view on a matter of public policy contrary to the religious belief of the person refusing to express that view. And of course, the point at which we draw attention, bearing in mind the approach of Lord McDermott and the Northern Ireland Court of Appeal in Ulster Transport, was, of course, it's only if one gets to that inevitable, if the clash is inevitable. If one can avoid it, then so be it. In answer to question 2, the court is asked to confirm that there was no power to make, confirm or approve Regulation 5 of SOR to the extent that it imposes civil liability on those who refuse to provide a service which involves the expression of a political opinion inconsistent with their religious belief. And in answer to question 3, the court is asked to confirm that in light of the prohibition in section 17 of the Northern Ireland Constitution Act 1973, Article 28 of the Fair Employment and Treatment Northern Ireland Order 1998 is void insofar as it imposes civil liability for the refusal to express a political opinion or to express a view on a matter of public policy contrary to the religious belief of the person refusing to express that view. And finally, in answer to question 4, the court is asked to confirm that paragraph 33 of Schedule 10 to the Northern Ireland Act 1998 permits a reference to be made under that provision when the requirement for such a reference has been made after the judgment has been given on a relevant devolution issue, but before the court order has been finalised.
So the answer is yes to all of the questions.
Yes. Yes. But yes, in terms of the, if one gets to that.
Oh yes, insofar as.
Yes, insofar as one gets to. Yes. Respectfully.
It's a prior question as to.
Indeed.
In a way, it's a prior question, not to question 4, but to each of the other 3, whether there is in fact civil liability in this case.
Respectfully.
Yeah.
Unless there's anything else, ladies and lords, those are my submissions.
Any questions? No questions. Right. Thank you very much indeed, Mr. Attorney. It seems to me that we've reached a convenient moment at which to adjourn, and we will look forward. I think it's your turn at 2 o'clock, is it not, Mr. Allen?
Lady,
yes.
I was just going to rise to my feet to say that I would use 5 minutes if you were willing to sit for 5 minutes, but because there are 2 short points I can make before 1 o'clock.
Well, your 5 minutes would come off your time after.
Well, I was going to try and bargain over that, if I may, my lady, but only on the basis that I have 3 hours and they have 6 against me. So it's just wondering whether it was a little bit of equality of arms to say I could have 5 minutes more. But
well,
if you say no, I will sit down.
I propose to say no. No? No. Sorry, Mr. Allen.
It's all right.
Sorry.
You make the rules, not me.
Well, we invite counsel to divide the time that we have
lady.
available between them Council have divided it in the way that they
I
have.
understand, my lady.
We were happy with that division, but I don't think it's for
I think it's better
us to take a view on the relative fairness of the allocation
I
of time
think
that's been agreed.
My lady, I'll detain you no longer from your lunch.
But we will look forward to hearing from you at 2 o'clock.